8:02, so we will jump in. Again, good morning, everybody. Welcome to our roundtable dealing with Delta. A couple of administrative matters to open, as always. This session is being recorded, and at some point shortly after the conclusion of the session, I know our intrepid marketing director, Aaron Larson, will be sending out to all attendees a link to the program and to handouts. So I wanted to note that. We've got a lot of attendees today here. Oh, here's our disclaimer. So thank you, Aaron, for advancing. Part of the disclaimer I know is that everything in these kind of programs is very date stamped. You know, every day something seems to be changing on the COVID front and the vaccination front now. It has been for a year and a half. So the information presented today is sort of a moment in time, and we want to make sure people are mindful of that and aware of that. And so that is the reality we all live in, that the things are subject to change. And today is what, the 21st, and today the information is good as of today. Next slide, Aaron. The other thing I wanted to, on the administrative front, mention as we get going is that if people do have questions along the way, it's a big crowd today. We're expecting well over 100. Potentially over 200 attendees. We'll see how far the numbers climb. But we do try and answer questions in real time in the chat function. And so we'll try to do that. If you have any questions, feel free to put them in the chat function, and we'll try to answer them as we go or at the end if there are themes that people have questions about. So there's that. Okay, jumping in to the first slide. This is the agenda for today. We're in the introduction phase of the program. Man, what to say by way of introduction? This has been quite the topic. Vaccinations. It dominates most of our days on the counseling front. I mean, people have questions about. A couple of weeks ago, it was whether we should have mandatory vaccination policies. Then it's kind of morphed into the exemptions. And a lot of folks have decided to take that leap and have a mandatory vaccination policy based on what we're seeing from the government and from big companies. And then the devil becomes the details about the exemption requests. And people still have this sort of, I'm reopening my office. I had this big plan to reopen the office after Labor Day, and now what? The variant still seems active. How does that, how have safety requirements, changed or affected my reopening plans? All that kind of stuff. So we've got an hour and a half program, too much to cover. We could take on any one of these topics and probably fill the whole thing, but we'll try and touch on all of them. I will say this about the Delta variant. We named this program how long ago? Over a month ago. We came up with the title of this program. And one of our colleagues who likes alliteration or puns, I think, came up with dealing with Delta. I was kind of half wondering if it was going to turn into Lambda. We'd be living with Lambda or something, but the Delta variant does seem to still be the variant. I think it's responsible for 99% of the cases in the US. We've all learned more than we ever wanted to know about variants and COVID vaccination. There are a number of variants out there besides Delta. The variants are actually classified by the World Health Organization, the CDC, as a variant of interest or a variant of concern or a variant of high consequences. Who knew? But we are sort of dealing with Delta, and it's technically a variant of concern, not yet a variant of high consequence, if you follow the terminology, but neither here nor there. So we'll jump in and we'll talk about starting with sort of the biggest and most recent development of President Biden's announcement and the upcoming OSHA standards. And then we'll move on to mandatory vaccination policies, considerations, reopening, talk a bit about exemption requests. As I say, that kind of seems to be the frequent flyer question and issue that people are facing. And we'll talk about leaves of absence, which has been a frequent flyer issue for the better part of a year and a half. So with that, by way of introduction, quickie introduction, I'll turn it over to Mark, who's going to talk about President Biden's recent announcement.
I think we're going to send it over to Kathleen to start out about President Biden's announcement, but thanks.
All right, first switcheroo. All right, sorry about that, Kathleen.
No, that was just a way for us all to say hello. Thanks, Pete. Next slide, please. So this announcement that President Biden made on September 9th, we wanted to lead off with that because we figured it is top of mind for all of you on this webinar today. And as you probably know, on September 9th, President Biden held a press conference and he introduced the administration's what's called Plan to Stop the Delta Variant and Boost COVID-19 Vaccinations. It's the path out of the pandemic. And you can click on the link we've got in our slides that we'll be sending you. And it's very reader-friendly, issued by the White House. This plan lays out a national strategy with 6 prongs to combat COVID-19. For our purposes today, the first prong, which is vaccinating the vaccinated, is what we're going to focus on. In describing and outlaying the plan, President Biden doubles down on his announcement for vaccination requirements for employees of the federal government that was issued in July of 2021. And in this plan, he further touts the effectiveness of vaccine mandates in private industry. For example, the plan explains how in the beginning of August, when Tyson Foods announced its vaccine requirements, at that time, only 45% of its workforce was vaccinated. But a month later, as of September 9th, the date of Biden's announcement, 72% of Tyson's workforce was vaccinated. He similarly mentions the effectiveness of the United Airlines vaccine mandate. The plan cites how currently there are 175 million Americans who are vaccinated, and this plan seeks to use regulatory powers to increase the vaccination rate across the country. Apparently, right now, there are approximately 80 million Americans who have not gotten their first shot yet, and they are, of course, the focus of this plan. So what are the regulatory components of this path out of the pandemic? First, President Biden issued an executive order mandating the COVID-19 vaccination for all federal employees. This order provides that each federal agency shall implement a program to require COVID-19 of all federal employees. In fact, just yesterday, the Safer Federal Workforce Task Force, which is tasked with releasing the guidance related to this plan, issued guidance for federal employees in the form of FAQs on the vaccine mandate. Basically, what those FAQs tell us is that by November 22nd, 2021, all federal employees are required to be vaccinated, and there will only be limited exceptions for an employee's sincerely held religious belief or a disability. And interestingly, the mandate applies to all workers, regardless of where they are located, so even remote federal employees. And the FAQs state that if an employee fails to get the vaccine as required under the policy, they should first be provided with information about how to get the vaccine and the benefits of the vaccine. And if they continue to refuse to get vaccinated, then the agency can put them on disciplinary measures up to and including removal from federal service. So that just came down yesterday for federal employees. The second piece of the plan in the regulatory context is President Biden's executive order mandating COVID-19 vaccines for federal contractors and subcontractors. And this will likely follow what I just described above for federal employees. The Safer Federal, this task force I mentioned, is currently developing these safety requirements, and they're due to be issued September 24th. Third, and this is what I'm sure many of you anticipate hearing about on this webinar, is President Biden's announcement of the ETS, the Emergency Temporary Standard, to be issued by OSHA. And Erin, if you could go to the next slide, please. Oh, sorry, can we go back for 1 sec? One thing I wanted to mention before we shift gears to the ETS is that there is also a requirement that CMS and the CDC are jointly putting out in some form of regulations via weight that will greatly expand the requirement that healthcare facilities that receive Medicare and Medicaid funding also have their staff vaccinated. And with that, we can move to the next slide for this emergency temporary standard. We don't have this emergency temporary standard in place yet. We have what President Biden tells us in the pandemic plan will be forthcoming. Right now, OSHA is drafting these regulations, and we anticipate that they will likely be issued sometime in the next few weeks, perhaps early October. What we do know is this, that all employers with 100 or more employees must require their employees to either become vaccinated or to provide a weekly negative COVID test prior to entering the workplace. And when I say employers, I'm speaking right now, of course, of private employers with 100 or more employees. In addition, private employers with 100 and more employees will be required to provide paid time off for their workers who are receiving the vaccine or recovering from the side effects of the vaccine. This ETS, when in effect, is anticipated to target those 80 million unvaccinated employees or individuals out there in the United States. Now, this ETS won't be issued without controversy. It's very rare or infrequent for OSHA to issue these ETSs. In fact, the ETS that issued in June of this year, June 21, for healthcare workers was the first ETS issued in 38 years. Certainly, as with everything COVID over the last year and a half or such, there's political divisiveness and great opposition to this ETS. You can see I provide you with the standard that is required for OSHA to issue an ETS. And although not very high, it does require that this grave danger standard and the necessity of an emergency standard to protect employees from danger. What will likely happen is the standard will issue, and typically they issue with a 6-month comment and rulemaking period for folks to weigh in. But in this case, it will likely go right into effect. And from there, the rulemaking procedure will go into effect. So the bottom line, I think, at this point is we don't know exactly what it's going to say, but what I've just discussed with you are the highlights, and it probably won't give a very long timeline for employers to prepare for this requirement of either full vaccination or weekly testing. So it's a good thing for you to be thinking about right now. And that's it for me on this one. Mark?
Thanks, Kathleen. And thanks everybody for joining us this morning. So next we're going to talk about mandatory vaccination policies, which, as Kathleen discussed, in light of President Biden's announcement, may become a lot more widespread in the near future. So let's go to the next slide. All right, so let's start out with a few updates since the last time we had one of these roundtables. As we discussed before, until recently, all of the COVID vaccines being administered in the US were done through what's called an emergency use authorization, meaning that they had not received full FDA approval. As you may remember, there were some questions about the regulations governing emergency use authorized vaccines, which includes some language that allows the Secretary of Health and Human Services to require that individuals be told that they can refuse a product issued under an emergency use authorization. So the language was included in the fact sheet for Pfizer and Moderna that were available to recipients of the vaccine. And it was unclear at the time how far the regulation could reach and whether it applied to private employers and private companies who were mandating or planning to mandate the vaccine. Well, on July 6th of this year, the Department of Justice issued an opinion letter providing that emergency use authorization status does not prevent employers, schools, or other entities from mandating the COVID-19 vaccine. Now, while the DOJ's opinion letter doesn't, have the force of law, it does provide some assurances concerning how the regulation is to be interpreted and is consistent with our beliefs that the regulation containing the right to refuse language concerning emergency use authorization wasn't intended to impact private employers' policies. So, one less thing to worry about or to be concerned about when, if you are deciding to issue a mandatory vaccination policy, where most of the vaccines out there right now are still subject to that emergency use authorization. And then another huge update along similar lines is that on August 23rd, the FDA gave full FDA approval to the Pfizer-BioNTech COVID-19 vaccine for individuals 16 years of age and older. Now, this is hopefully a big step in easing employees' vaccine-related concerns, as we had previously heard some pushback about getting the vaccine before it was FDA approved. Now, the Pfizer vaccine remains emergency use authorized for individuals 12 through 15 years of age, and for the Moderna and Johnson & Johnson vaccines, they continue to be administered pursuant to the emergency use authorization. Also, just one other note is recently Pfizer announced that its vaccine has had positive test results in its trial involving children that are aged 5 to 11. So we may see an expansion of the availability across that age group in the near future, but nothing on that right now. If we go to the next slide. So with a little of that background in mind, we are going to open it up for our first polling question. And that is, has your company or organization implemented a mandatory COVID-19 policy? And as you'll see, the answers are yes or no. So please take a moment to just respond to that question. All right, so we got our responses, we got our answers, and it looks like 29% of participants have implemented a COVID-19 mandatory COVID-19 policy, and 71% have not. So, thanks everyone for responding to that. And on similar lines, we have another similar question. If we go to the next slide. So for those who answered yes to the previous question, do you anticipate losing employees as a result of, the mandatory vaccination policy? And the responses are no, yes, but only a few, and yes, a significant number, meaning that, you expect to lose a significant number of employees because you implemented a policy like that. So please take a moment to respond to those questions. And to Mary Lou, yes, the policy relates to questions for a mandatory vaccination policy. All right, so we have our answers in. 39% of respondents said no, they don't expect to lose anybody. 48% said yes, but only a few. And then 13% said yes, a significant number. So the yes, but only a few, outpaced the rest of the answers. And I think that's about where we would expect the answers to go. When, as I'm going to talk about in a little bit, when you implement a mandatory vaccination policy, there are some employees, you're probably going to see some employees who, are just so opposed to getting the vaccine that they'd rather leave the company than, get the vaccine. So hopefully it's not too many, and hopefully, that significant number of employees comes down, as more and more information comes out about the vaccines. So let's go to the next slide. All right, let's talk about mandatory versus voluntary vaccination policies and some matters to consider in deciding on which type of policy to issue. So first, starting with legal challenges. As you may have read about, there's been some litigation throughout the country regarding employer vaccine mandates. Pete's going to talk about a little later in the presentation, the religious and medical accommodations, which is an area where litigation can arise in the vaccine context. But as far as, but for purposes of this discussion, I'm going to be talking about facial challenges to mandatory vaccination policies. And on that point, the litigation that has probably garnered the most attention was the case involving Houston Methodist Hospital from earlier this year. Their employees were required to be vaccinated by June 7th, 2021, or face termination. And on June 7th, the 178 employees who were not vaccinated were suspended by the hospital. And of those 178 employees, 117 of them joined a lawsuit seeking to block the vaccination requirement and their terminations. Now, in dismissing the case, the judge out of the United States District Court for the Southern District of Texas found that the hospital's mandatory vaccine policy was lawful. And in reaching his decision, the judge recognized the legitimacy of the hospital's goals in mandating the vaccine, and writing in his opinion, and I quote, Methodist is trying to do their business of saving lives without giving them the COVID-19 virus. It is a choice made to keep staff, patients, and their families safer. The employees can freely choose to accept or refuse a COVID-19 vaccine. However, if they refuse, they will simply need to work somewhere else. So it's that last point that is particularly strong and is hopefully a guide in any future litigation that may arise. That the employee is not being coerced into getting a vaccine. They're really just being left with a choice. They can get the vaccine and continue working here, or they can choose not to get the vaccine. But if they choose not to get the vaccine, they're going to have to find work elsewhere. And I think that's going to be the case for a lot of the mandatory vaccination policies. And hopefully, as more and more litigation gets brought on this matter, courts continue consistently identifying this as the appropriate approach. And this point goes to our next bullet, which is the practical considerations. So something we've been saying since we started presenting about the vaccine and, as alluded to in our polling questions, there is real potential and even a likelihood that some employees would rather leave your employment than get vaccinated. For employers thinking about issuing a mandatory vaccination policy, this is one of those areas that you should be considering and be prepared for. It's important to administer a COVID policy consistently, which means that if your policy applies to salespersons and your top salesperson is refusing to get the vaccine for an unprotected reason, you should be prepared to terminate or suspend the employee just as you would any other employee violating the policy. Employers may also consider alternatives to a mandatory vaccination policy. This may include a policy under which employees who are not vaccinated either work from home, have to present a negative test result periodically, or wear a mask at all times while at work. Now, with this type of policy, you don't have the same issues with potentially losing employees who don't want to be vaccinated. But with the flip side of that being that some employees may feel less safe in the workplace, knowing that some of the employees or their coworkers aren't vaccinated. It's important to remember that except for those industries where governments have mandated vaccines, the decision on whether to implement a mandatory or vaccination or voluntary vaccination policy, it's really up to the employer. In coming to that decision, you may consider some of the topics already discussed, as well as company culture and mission, employee sentiment, whether you're in a customer-facing industry, as well as the health and safety of those who you work with and who you employ. But really, at the end of the day, the decision is going to be up to you, the employer, to make. Once you do decide that you want to enforce a mandatory vaccination policy, you'll have to consider the best approach to implementation. So one logistical decision to be made is how employees will be expected to provide proof of vaccination. Will employees be asked to show a physical copy of their vaccination card? Will they be required to email a picture of their vaccination card? And who's going to be checking for vaccination status? Is it the front desk person? Is it HR? What we've seen a lot of is that employers will have employees send a picture of the vaccination card to a member of the HR team, and the HR team member would then keep proof of the employee, proof of that employee's vaccination status in the employee's confidential medical file, which is separate from that employee's personnel record. And then another question on implementation has to do with timeline. So employers should consider when they want employees to be fully vaccinated by, and then provide a reasonable amount of time for compliance. So what I mean by this is, the Moderna vaccine, for example, requires 2 doses, with the second dose, 28 days apart from the first. It wouldn't be reasonable to roll out a policy then that requires employees to be fully vaccinated by the following week or face termination. So you may consider announcing a COVID-19 mandatory vaccination policy 6 weeks to 2 months in advance of the date on which employees are required to show proof of vaccination. That might be a reasonable announcement time, a reasonable time that allows the employees to become fully vaccinated by the date on which you want the full vaccination to be presented. And of course, if you plan to have a mandatory COVID-19 vaccination policy, you're going to need to implement an actual written policy. So what goes into this policy? If we can go to the next slide. One topic to address is, who does the policy apply to? Is the policy going to apply to all employees or just employees in certain roles? We've seen both. We've seen distinctions made between client or customer facing roles versus back of the office type roles that may not require much face-to-face interaction. There were also some employers requiring vaccination only for those employees who wish to come into the workplace or attend in-person work events. So, the first thing you're considering in writing up the policy is who the policy applies to. Next, what is required under the policy? And this goes along the lines that we discussed with implementation. What are you actually asking the employee to do? This includes, by what date or what specific event employees will be required to be vaccinated, and also how they are, what mechanism they are to use to show proof of vaccination. And that goes to the whole, whether you're asking them to email a picture of their vaccination card or, show a physical copy of their vaccination card to somebody who, in HR or at the front desk. The goal here really is to be clear with employees about expectations. So you're going to want to put it right there in the policy, what you're expecting of employees to show their proof of vaccination. There should also be a provision in the policy that states that employees who are unable to receive the vaccine due to religious or medical reasons may seek a reasonable accommodation. And again, Pete's going to talk a little bit more about what reasonable accommodations are and what you have to do later in the presentation. I just want to make the point that the language about the potential for an accommodation should be right there in the policy. And this could be helpful in case there's litigation on a terminated employee who never requested an accommodation, and then they start claiming when they get to litigation that they were unable to get the vaccine for a religious or medical reason. We'll be able to point to the policy, say, we informed the employees that, they were supposed to request a reasonable accommodation if they had a religious or medical reason, and this employee never did so. And that could help us, if we do ever have to go through litigation on that point. And this goes to this last point about consequences of noncompliance. So if employees who fail to be vaccinated by a set date or event will be terminated, you should be explicit in the policy on that point. We don't want there to be any confusion about whether the employee knew of the consequences of their decision not to get vaccinated. You may include the standard phrase you've probably seen in your handbook around discipline that states, an employee who fails to comply with this policy will be subject to disciplinary action up to and including termination of employment. I'm sure we have all seen this language before, whether it be in our handbook or in certain policies. And this phrasing of the consequences may be preferable because it leaves open the possibility of issuing a suspension with a mandate to get the vaccine by a future date or to face termination. So you might set the date and say, you know, if you're not vaccinated by this date, you're going to face disciplinary action up to including termination. And if they don't get vaccinated by that date, you may choose to suspend that employee rather than outright terminate them and say you're going to be suspended, through X date. And if you don't get your vaccination by X date, you will be terminated. Kind of gives them a second chance at that point. While I'm sure we could talk all day about vaccination policies, and if you would like to implement a policy, I would encourage you to reach out to your go-to lawyer at HRW. For now, I'm going to turn it over to Kathleen to talk a bit about reopening and safety around that.
Thank you, Mark. Reopening and safety, what to say? Next slide, please, Erin. This slide I include just to give some context for where we are today and where we were in 2021 and where we are today. As you will, I'm sure, recall, on May 13th, the CDC released guidance for vaccinated individuals. And that was a big mic drop. That guidance said that vaccinated individuals no longer needed to social distance, no longer needed to wear masks or face coverings while indoors, or get tested for COVID-19 after exposure unless they showed symptoms. And within 2 weeks of the CDC's announcement, states all over the country, including the Commonwealth of Massachusetts, lifted all business restrictions, mask mandates, all travel orders. And by May 29th, that's where we were here in the Commonwealth with all those restrictions lifted. Forward the clock, as Pete said in the introduction, we are now dealing with Delta, the Delta variant, and with the breakthrough of, in some instances, Delta in vaccinated individuals and its highly infectious nature and the number of unvaccinated individuals in the United States. In July, the CDC updated this guidance and revised it based on the Delta variant. And this guidance notably says that vaccinated individuals in indoor settings in areas of high or substantial transmission area should wear face coverings or masks, even if vaccinated. Now, we're in Suffolk County, in Boston. We are one of those areas of high transmission or substantial transmission. The guidance also changed the testing recommendations. Now, vaccinated individuals who come into close contact with either a suspected or confirmed COVID-19 case are encouraged to get tested. And after 3 to 5 days of exposure, because earlier than that, it's typically not accurate. And they're also encouraged to wear a mask for 14 days or until they get that negative test result. Now, I just mentioned this because this guidance has been a beacon for many of our clients throughout the pandemic. And keeping up on this changing guidance, we all seem to be part-time epidemiologists, whether we like it or not these days, or at a minimum, following what the CDC recommends. As you take your steps to keep your workplace safe, decide when to reopen your workplace, whether to postpone that, whether to mandate, et cetera. And next slide, please. What doesn't change, what always remains the North Star here is the employer's requirement to maintain a safe workplace, a workplace free of hazards. This guiding principle, I know you're all very much aware of. And I will also add that the EEOC's technical assistance guidance, which continues to be updated, it hasn't been updated since May, but they have updated on testing, on health screening, and then in May on vaccination mandates, reminds employers that they really do need to keep on top of this guidance and that it will likely change. And so the bottom line here is that we are here to help you, but it's important that you keep on top of what the CDC is saying as you look at your policies. Next slide, please. These should look familiar. On this slide, I provide a summary of some of the topics that still apply one way or another for most of you who have reopened your workplace or are about to reopen your workplace. These areas still warrant consideration, and some of your policies may remain the way they were in 2020, or they may have changed, or they may have changed in early 2021, and now they are changing again. We're going to use some of these topics I'll use a hypothetical in a moment on our next slide to address some of these areas, but you'll see the highlights here are we still all do not want employees in the office when they're sick. Vaccinated versus unvaccinated, whether you have policies around that. And of course, thinking through what this is all going to mean once this emergency temporary standard issues in the next few weeks will change or influence your policies on vaccination and testing requirements, your social distancing, and things like that. So let's move on to the next slide and talk about these in a hypothetical. So in our hypothetical, Acme Inc. is just reopening their Boston office for all 125 employees, and you, the HR director, have a host of questions to answer. Question number 1, must Acme require all staff to wear masks in the workplace? Well, we know, first of all, from our little hypo here that Acme is based in Boston. So the question then becomes whether there is any, I think, starting point of whether there's any law, executive order, et cetera, that we should be looking at. And there is in Boston an order requiring face coverings in the city of Boston, and that issued in August. And so the question is whether that would apply to Acme. Now, I didn't give you a lot of information here, but let's just assume that Acme is an office and they're not open to the public, in which case the Boston mask mandate, which applies to business indoors on the premises of a business, club, place of assembly, or other place that is open to members of the public, requires face coverings. Now, Acme is not open to the public, so at the Boston mandate or mask mandate level, you're not required by law to have masks in your workplace. However, your next question is what you would like to do for your business, for your employees and your industry. And certainly there are many factors that I'm sure you've already thought about, including the number of unvaccinated employees in your workplace. If you have a 100% vaccinated workplace, perhaps then you can have no masks in place. However, there are those breakthroughs of Delta occurring in some number of vaccinated individuals. So we have been seeing employers reinstitute, in some cases, the mask mandates that they had lifted in May or June of this year. Again, there's no hard and fast rule for much of this stuff, at least right now. So you'll just have to think about your workspace, your employees, their expectations, your industry, and all of those other issues that surround answering that question. Okay, question number 2. Acme plans to require vaccination or weekly testing of all employees at their own cost. Is this legal? This one has been popping up in the chat box. So I've been telling you, some of you in the chat box, that we would address this, and so has Kathy Rubin answering those questions. So here we are. First, with respect to the question of whether weekly testing requirements of employees is legal, yes. So long as there's a non-discriminatory application of your testing requirements. For example, it is reasonable that you would require weekly testing of all your unvaccinated individuals. That's perfectly lawful. And the EEOC's technical assistance guidance addresses this. Second, however, the requirement that Acme's requirement that its employees pay for weekly testing is problematic, at least in Massachusetts. If this test is a condition of employment, a Massachusetts employer may want to take the most risk-averse approach here and pay this employee for the time, for reimburse them if they're required to outlay the money in the first instance for the test, certainly, and potentially pay them for the time for a non-exempt worker to take the test if it's outside of business hours. We say this because the point here is to try and avoid a wage and hour claim. And there is a statute in Massachusetts, General Law 149, Section 158, that addresses in a slightly different context that an employer is required to reimburse prospective or current employees for medical examinations. And although the text of that law addresses medical examinations by a physician designated by the employer, which is different than what we're talking about here, it's pretty close. In addition, under the Americans with Disabilities Act, generally speaking, if an employer requires testing as a condition of employment, that is generally covered, paid for by the employer. So there might be some different decisions with respect to your organization that we could take offline, but as a general risk-averse approach, this would be a good way to think about addressing the testing issue. Okay, next question. Question number 3, you learn that a vaccinated employee has been exposed to COVID-19 in your workplace, or has been exposed to COVID-19. It doesn't matter if it's in your workplace or just anywhere. What do you do? This is certainly something I had listed on the prior slide. And you as an employer are going to want to think about this and determine what your policy and procedure will be. You don't want to be caught short the day it happens, because everyone flies into a panic when these kind of things happen. A good place to start, as I've said before, is CDC guidance. And right now, again, subject to change, but for today, the CDC's guidance as of September 16th says that individuals, vaccinated individuals, who are in close contact with someone who tests positive for COVID-19 and who don't have any symptoms, so they're asymptomatic, should self-monitor for 14 days, but they are not otherwise required to quarantine. In addition, the CDC encourages vaccinated individuals who are exposed to get tested during that 3 to 5 day window after the exposure, and to wear a mask in public indoor settings for 14 days or until they get that negative test result. Now, you may wish to incorporate these recommendations into your policy for your vaccinated employees. Keep in mind that the CDC has different recommendations for unvaccinated individuals. For those individuals, they should quarantine for 7 to 10 days or get a negative COVID result after day 5. So query whether you want to have one blanket policy that applies to everybody that you hear about being exposed, or whether you'd like to have this distinction between vaccinated and unvaccinated. Next question, Erin, please. You learn that an unvaccinated employee is traveling to a known COVID-19 hotspot for vacation. What are ACME's options? Well, for our Massachusetts employers on this webinar, I'm sure you will remember the travel order issued by Governor Baker last year, requiring quarantine or testing within 3 days of return from locations throughout the high-risk locations throughout the United States or abroad, which on the United States was basically almost every state. Well, that travel order, like everything else, as we know, has been lifted, so we don't have that to cite to in terms of a travel policy. Nonetheless, as you know, employers can set policies that of their own to keep their workplace safe. One thing I've seen is employers requiring their employees who travel for personal reasons outside of Massachusetts or outside of the country to notify the employer if they do travel to those places, and require a negative COVID test for returning to work. there's so much right now. We're lucky in that there are so many more tests available than there were at certain points last year, or during the height of COVID. So and that's what would be up to you. I've been seeing questions pop up in the chat box about what kinds of tests can employers utilize. Here's one black letter law I can tell you what you cannot use, which is the antigen test. That is a test that doesn't necessarily tell you if you have COVID now. It just shows you tells you if you've had COVID in the past. And the EEOC's technical guidance says that violates GINA because it provides genetic information. So we know you can't use that, but certainly your policy could, unless this emergency temporary standard tells us something different, you could use the COVID-19 home PCR, home tests, or you could require a PCR test at a site. That will be up to you. What is also important is that whatever policy you institute, if you have the appetite to question your employees about their personal travel, that you apply that non-discriminatorily. So your C-suite folks get asked just as your line workers or non-exempt workers do. Also, I think to the extent that your employees, if they are doing any business travel for you, I think it's wise to have some language around requiring that they follow the COVID-19 protocol mandates in the jurisdiction or state in which they're visiting. And last, Erin, last question, please. If ACME mandates vaccination, are we going to have to ask for proof of booster shots? We've been hearing about booster shots and await certain announcements around whether they're recommended or not recommended for the general population. It sounds like they will be for those who are immunocompromised or older individuals. So they certainly will likely be something we all are required to get at some point in the future to be considered fully vaccinated, as the CDC defines that term. I think a good approach here, and Mark talked about the components of a vaccine policy, would be to use the definition from the CDC of fully vaccinated, so that whatever that is at a certain point in time by the vis-a-vis the CDC, your folks will be required to be in compliance with that. And with that, I'm going to turn it over to Pete.
All right. Hello again, everybody. Thank you guys both. Boy, exemption requests. So this has become, the area of frequent flyer questions for all of us, I think. And it's interesting. A lot of the exemption requests focus on religion. Next slide, Aaron, while we're talking about this, by the way. It used to be like that religious accommodation, because that's what we're talking about. There could be other bases for accommodation. We'll get into them all with COVID, but the main one, the one that is giving everybody a little bit of pause and seems to be dominating the number of requests, is about a request for a religious accommodation, an exemption from a mandatory vaccination policy. This so rarely used to come up in employment law, right? It used to come up if somebody wanted a particular holiday off, or said they couldn't work weekends because of their Sabbath recognition, or being personal grooming. It was this little thing that came up every once in a while that you had to deal with. And now, bam, it's front and center. It's become something everybody's talking about in the employment law world, is the scope of the extent of religious accommodation and how it impacts exemption requests. So it's a little bit ironic too. I mean, the Pew Research Center has done surveys about religiousness in America, and how the numbers of folks who are affiliated with an organized religion has really been dropping precipitously in years. The last study showed it dropped 12% over a 10-year period. And then conversely, the number of folks who are unaffiliated or identify as atheists or agnostic has risen to over a quarter of the population. You wouldn't know it from the religious exemption requests we're getting. There is literally a cottage industry out there now on this issue. And you guys have probably seen it in HR. When somebody's making a religious exemption request, the language seems to be somewhat similar now. It tends to come in two forms, right? One is have an objection to the vaccination on religious grounds. And it comes back to my belief that the development or the contents involves aborted fetal tissue. That's one area. The other is that my body is a temple of the Holy Spirit area. There's a scripture quote that seems to be a frequent flyer. But you can go online and these forms, these templates are available. And there's even been headlines about pastors of churches that are essentially selling signed religious exemption forms as long as you make a donation to their church. So it's really turned into this whole thing. And it's become, as every HR person operating today knows, an issue we've all got to face. So the questions that come up, right, are particularly in religion. I think that's the more interesting topic to talk about, what we'll focus on. But, who determines what's a sincerely held religious belief? That people are struggling with that. And I think there's an answer to that question, but you can tell that everybody's really frustrated with what seems to be political or personal preference or health preference or whatever it might be being couched in religious terms. And there's a desire to sort of push back on that. So first question we can talk about is, well, should we push back? How much can we push back? What does the law actually say about our ability to push back on that? Another question that comes up is, well, what does somebody need to show? We know if they're asking for a medical exemption to vaccination, we're going to hear from the healthcare provider. What's going on? Why does your condition preclude you from meeting our vaccination requirement? How much information can we request on the religious front? I want to know from your pastor. Yeah, I want to hear from the Pope himself. I've heard from the Pope himself, frankly. That's what a lot of employers are saying, that the Catholic Church is not opposed to vaccination. How do you as a Catholic justify your stance? How much can you push back? What can be asked of the employee to show that? And then maybe the bottom line question is, can you still say no? Suppose an employee does have a sincerely held religious belief or even a medical reason for not wanting to get vaccinated. Can we still say, look, we accept that you have a basis for this request, but it's just the answer is no. So these are the kind of things we'll talk about. The reason this slide is shown is because this is sort of the genesis of the current understanding of the law in this area. This is the sort of the headline of an EEOC guidance that has been developed and added to and updated ever since the pandemic started. And this one says updated on December 16, 2020. It's been updated since, but that's when the EEOC back in mid to late December, came out with the piece of this guidance that talked about mandatory vaccination and accommodation. And so next slide, Aaron. It gets into detail and you can kind of dig into a little bit further about what is reasonable, what isn't, but this is kind of the heart of it, the frustrating heart of it, and it is the law, right? It says, and this is a quote from the EEOC, in some circumstances, Title VII, that's where the religious accommodation need comes from. Some circumstances, Title VII and the ADA, it's medical, you got religion and medical, require an employer to provide reasonable accommodation for employees who, because of their disability or sincerely held religious belief, practice, observance, don't get vaccinated, unless providing the accommodation would pose an undue hardship. There it is. There's your whole sentence, and that's the law in a nutshell. You got to give a reasonable accommodation, but not if it's an undue hardship. And you get very little practical guidance about what that means. And all these laws that come out, the Department of Public Health in Massachusetts has required vaccination in nursing homes. But even the law says, mandatory vaccination, except you got to allow exceptions as required by law. Everybody kind of just throws that caveat in there and leaves it to the lawyers and the HR people to figure out. I think President Biden's, instruction to OSHA, we're going to see the same thing. You got mandatory vaccination, except you got to allow exceptions required by law. So that's kind of what we're going to talk about here is, well, what does this required by law really mean? So let's go to the next slide. And I think this is safe to say, right? There are three bases for a exemption request that we need to consider by law. Medical. If somebody has a medical basis for requesting an exemption to your mandatory vaccination policy, we know the ADA talks about reasonable accommodation, undue hardship, that whole analysis. We've got to consider that request. Religion's another one. That stems from, on the federal side, Title VII, but there's a state law prohibiting religious discrimination and requiring accommodation as well. So we've got two separate sort of wings, different bases in the law, but ultimately come down to that, I think, need to have an interactive dialogue with an employee and talk about the basis of the request and the undue hardship versus reasonable accommodation and pregnancy. Pregnancy to me is a definite yes because of our own state law here in Massachusetts, the Pregnant Workers Fairness Act, which requires accommodation for pregnancy, sort of in the same way you'd have to think about it for a disability. Absent that, I mean, pregnancy accommodation for COVID, kind of a wing of the ADA under medical, but I put the three out there. I think the three are, stand on equal footing in terms of a need to consider a request for an exemption on those three bases, talk about the accommodation dialogue, et cetera. So next slide. So like I said, let's focus on religions. I think that's the one that people are hearing about the most and trying to figure out what to do with. So one thing I found interesting in all this, like I said, the need to accommodate in the basis of religion comes from a different place than the need to accommodate in the basis of a medical condition, a disability, Title VII versus the ADA. And you're seeing governments, at least, I wouldn't recommend this for a private employer, but you're seeing governments come out with vaccine mandates that just don't purport to recognize a religious exemption. The DPH in Massachusetts didn't do it that way. The Department of Public Health, when they imposed mandatory vaccination on nursing homes, they mentioned religious accommodation and disability, but other states haven't. They just said, they talked about a medical accommodation and as if they're not going to consider religious accommodations. I would not recommend that for a private employer. So I just wanted to get that out there because sometimes you'll see that. And I've talked with clients on the phone, like, well, they're kind of skeptical of the religious accommodation requests, and they're much more sympathetic to the pregnancy or the ADA. I don't think for private practice, private sector employers is really a basis to put that religious accommodation on different footing. So I just want to get that out there because depending on what you see and what you read, you might see a notable omission of religious accommodation. But I think that stems from some of the government mandates in this area. So anyway, the bullets. The first bullet just acknowledges sort of where this stuff comes from, different places, Title VII versus ADA, but we do have the State Fair Employment Practices Act, which mentions prohibits discrimination on the basis of both, but specifically talks about religious accommodation. Second bullet, sincerely held religious belief. That's the operative language. And this is where I think some folks can get tripped up on or really have a problem with what the law, unfortunately, for better or worse, tells us. The federal law, I believe, has always sort of used that phrase, like someone's entitled to a religious accommodation, a reasonable accommodation, not an undue hardship, based on their sincerely held religious belief, if that conflicts with your policy or practice. And it used to be in Massachusetts that our law said something a little different. It said, if it was sort of a tenet of the religion, almost as if the employee had to prove that what they are believing is actually espoused by in some official way by their religion. And back in 1996, a case came down and the court in Massachusetts made it clear, and the law was amended in Massachusetts to make it clear, and I think this is relevant for COVID times, that basically you're not supposed to get too far into the weeds into whether this is a sincerely held religious belief. It's almost good enough if the employee says so. It's really that close, unless you got a bona fide reason to question that it's a sincerely held religious belief. That might justify you to ask a few more questions. But by and large, and the EEOC even says this, it's like usually it's gonna qualify. Don't push too hard on sincerely held religious belief. Now you're seeing employers nonetheless push a little harder these days, which is interesting. But the thinking behind this in the law is that the government shouldn't be in the business of deciding which religions are valid and which religions aren't valid. Your sincerely held religious belief, well, we think that's a little wacky. We're not gonna sanction that one. But boy, you belong to an organized religion, we'll approve that. So basically these laws and the interpretation of the laws are essentially acknowledging that the government doesn't want to be in the business of sorting out whose religious beliefs are worthy of acceptance and whose aren't. And so trickle down, neither should HR, because the law is not going to support that sort of parsing of things out. So did anybody see the news? Nonetheless, some people are pushing back on this. And I suppose it's a question of personal preference or comfort or what have you, or corporate culture. One way, an Arkansas hospital, this came out in the news the other day, I don't know if everybody saw this, the headline, is pushing back on this. I think there's some frustration with this frequent religious request, particularly among healthcare providers. This is a hospital system out in Arkansas, where folks were submitting a bunch of religious accommodation requests based on this belief that somehow the vaccines were developed through the use of aborted fetal tissue. And so the employer basically is making everybody sign an attestation. It says, oh, is that the basis of your request? Well, then I want you to attest to the following, that you also don't use, and they cite a whole list of common medications and drugs that utilize to the same extent, which is a very, very, very minimal extent, aborted fetal tissue. They said, I want you to certify that you don't use Tylenol, you don't use Pepto-Bismol, you don't use aspirin, you don't use Tums, Motrin, Lipitor, ibuprofen, X-Lax, Benadryl, Sudafed, Claritin, Zoloft. They gave, it was an educational effort, but it was also an effort to push back. And they're serious about it. They want employees to sign off that I will not use any of those drugs. So you see employers pushing, more maybe than I'd be comfortable with on this religious accommodation issue. I've seen, and some of our clients have done it, where they push back on a religious request saying, I want something from your pastor. I want a signed sort of document from your church that you saying is behind this. I'm not in love with that approach, but there it is. I mean, people are doing it. I kind of usually come down to the bar for establishing a sincerely held religious belief just isn't that high. And, I think it's easier to defend if we're denying a request for religious accommodation. It's easier to defend that the request itself is a hardship, or maybe that somehow there's a direct threat involved in here, which is another concept, rather than putting all our eggs in the basket of this isn't really a sincerely held religious belief. So anyway, where I'm going through this slide, and I'll pause to see if anybody else has any comments on this one. It's such a loaded topic, but these are some of the concepts that you see. Sincerely held religious belief, undue hardship, interactive dialogue. That's another one that's familiar to everybody in the HR world, but that's what we're talking about when we get a religious accommodation request. And then undue hardship, obviously, is the flip side of the coin to reasonable accommodation. So I'll take a pause there. If anybody of the colleagues wants to jump in, got any thoughts? I mean, everybody's got war stories and anecdotes at this point about religious accommodation requests. They really are the frequent flyer. But anybody got anything to add before we move on?
Yeah, I'll say that I agree with your approach, Pete, with respect to not digging too deep on, I don't like that checklist of what medicines you've taken that you mentioned that an employer used in that article. I do think, however, that it's okay to ask some questions, being very, perhaps even having a list of questions that you draft, and in the event that you question employees seeking religious accommodations, you ask them all the same questions. You need to get at what their sincerely held religious belief is. It's okay to inquire, but like you say, Pete, I don't think you should press too hard. That's it.
Yeah, thank you. I like it when people agree with me. That's good. Right. So let's go to the next slide, Aaron. And this is just a quick hit of cases. The first case isn't so much a religious accommodation case, but when you talk about people pushing back on mandatory vaccination policies, these are some of the ones that are the well-known cases in this area. The first one is that Houston case that Mark talked about. You just got to put that up there because that is the big case at the moment on folks who tried to push back on a mandatory vaccination policy in a hospital system in Houston. And it failed. It's on appeal, but that one failed quickly and summarily, with a message being clearly sent by the judge in that case. Another case we probably talked about in prior programs is this Robinson Children's Hospital case. That one came up in Massachusetts, so it's a helpful case to have locally. It involved a flu vaccine, not COVID, but it was essentially, bottom line is the hospital won, and it was determined that it would pose an undue hardship for people to have exemptions to the flu policy because it would put the health of vulnerable patients at risk. So part of the message from that case is, boy, if you're in the right industry, I think it's a lot harder to be more strict about enforcement and not allowing exemptions to your mandatory vaccination policy. A lot of the cases do happen to involve healthcare centers and hospitals, and I think they've got understandably an easier time of denying a request for an exemption based on undue hardship. The third case, this Fallon one, I mean, that's an interesting one because the court there did draw a distinction between someone saying, hey, you're not really making a religious request. What you're saying is, in that case, what? It's your belief that you shouldn't harm your body and that the vaccine may do more harm than good, were medical beliefs, not religious beliefs. Nice to see the court do that. And the EEOC has said, hey, if it's a personal belief, a political belief, a social belief, that's not what we're talking about. It's not a religious belief. I just wouldn't count on that. Like I said, that defense. I'd have it in pocket. And as Kathleen said, we can ask questions and probe about sincerely held religious belief. But I wouldn't want to fully rely on it, even though you get some cases where the courts did sort of recognize that distinction. On the flip side of the coin, you've got the last bullet, which is the EEOC was proudly touting back in 2016 how they got a settlement out of this Pennsylvania health center to pay $300,000 to some 6 employees who were required to take the flu vaccine. But there, the hospital did what I was talking about earlier, basically. The hospital apparently allowed medical requests, but didn't really allow religious requests. I don't know if that was their official policy, but that's apparently the way it played out. They had like 14 medical requests approved for an exemption from the flu vaccine, but the religious ones weren't allowed. And so the EEOC basically said what I said earlier, which is, no, you got to put these on equal footing. You got to at least have the interactive dialogue and talk about it. And they managed to get a settlement in that case. So, these cases illustrate these points that we're making. I just wanted to put the cases up there so that people at least understand where the basis of some of this, these themes and advice comes from. All right, we've got a couple of dense slides coming up, but I'll explain why. Next slide, please, Aaron. So the title of this says Interactive Dialogue, Undue Hardship. This is actually a direct quote, and the next couple of slides are directly quoted from the Massachusetts statute. Everybody talks about religious accommodation. It's nice to go back to the source material sometimes and say, well, what does the law actually say in Massachusetts? So this is it, and you'll see some, some of the bases for what the advice is embedded in the law. So without reading the whole thing, the first part of the bullet gets at, you can't require someone as a term or condition of employment to violate or forego a practice of his creed or religion as required by that practice, required by that creed or religion. That's the way the laws used to work. The fourth part of this quote is kind of what changed in 1996. It says, well, you can't force somebody to violate a practice of their religion. But to be clear, creed or religion means any sincerely held religious belief, without regard to whether those beliefs are espoused, approved, prescribed, required by an established church. So that's actually embedded in the law of the statute in Massachusetts now. They're very, very, very clear about sincerely held religious beliefs is way broader than you might think. Just because you disagree, just because you think it's illogical, et cetera, doesn't mean it's not a protected, sincerely held religious belief. And the other bullets in there obviously talk about reasonable accommodation and undue hardship. Okay, Aaron's fast forwarded me to the next slide. Good timing. So this is what the law actually says about undue hardship. And this is why I think this is a confusing area. This is the Massachusetts law. And when you read it, take a moment to read it, and you can see what they're thinking about is not vaccination. When this law was written, you know darn well what was going on with the thought process here. It says to establish undue hardship, that includes the employer being able to show that the inability of the employer to provide services, which are required services in compliance with federal and state laws, including regulations or tariffs required by a regulatory agency. Like, what are they talking about? Or it says, and when it goes on, that you can prove undue hardship, you can show that the employee's presence is indispensable to the orderly transaction of business, and his work can't be performed by another employee of similar qualifications. You go, what? What does that have to do with COVID? The answer is nothing. I mean, the law was really written with the thought in mind that what we're talking about is somebody needing time off, wanting to observe a religious holiday, or not wanting to be able to work on a weekend or something like that because of the Sabbath. So this is what we've got, though. This is what the law says about what undue hardship is. And there's very little carryover to COVID. So it's a bit of a head scratcher to say, well, what does undue hardship mean in Massachusetts when you're talking about a religious accommodation request? I would hope that it would harken back to the federal law. The federal law, by the way, has a different standard between religion and medical. So let me be clear about what I mean by that. If you dug deep into the law under the ADA and tried to figure out, well, what's an undue hardship? What's a reasonable accommodation? Somebody's making a medical request for an accommodation for my mandatory vaccination policy. there are explanations of what undue hardship is, and the answer is it all depends, but it's a somewhat of a high burden. It depends on the cost, depends on the individual circumstances, et cetera, et cetera. When you dig into the federal law on religious accommodation, it's a very low standard. And the EEOC even says that. They reaffirmed this back in that guidance I was talking about in late 2016. Anything more than a de minimis burden on the employer is an undue hardship if it's a religious request. That's what the federal law says. So in states not called Massachusetts or California or elsewhere that have their own state law, if it was purely the federal law we were looking at, you'd say, well, I feel more comfortable denying a religious request because the standard is so much lower. Anything more than a de minimis burden is an undue hardship on me. Of course, it's more than a de minimis burden to allow somebody an exemption to a religious request. So there are these different federal standards. We've got the state law, which is confusingly worded to deal with. The long and the short of it for me is, it comes down to this. I like to hedge our bets. I think it's fine to verify that someone's belief on a religious exemption request truly is sincerely held. And I don't think we have to necessarily say yes or no, we accept that you have a sincerely held religious belief if we're denying a request. But there's that angle on it, whether or not the belief is sincerely held religious belief. There's the undue hardship angle on it. Even if somebody does have a sincerely held religious belief, maybe it's an undue hardship to allow an exemption to our policies. There's possibly a direct threat analysis, particularly in healthcare. My gosh, how can we have you working here with that unvaccinated status? You're posing a direct threat to our patients, to our residents, to our coworkers. And then there's always the route of going an alternative accommodation. In other words, somebody says, I just want to be exempted from your policy. I don't think I should have to get vaccinated. My body's my temple, the Holy Spirit, et cetera. Say, well, that's fine. We accept that you believe what you're saying, but we can't give you the accommodation you want. I've got this other alternative accommodation for you. You can do X. Now, the EEOC would like to see alternative accommodations be in the form of remote work when that's possible, or filling a vacancy, but sometimes an unpaid leave of absence can be an alternative accommodation. So very often, cutting to the chase, we've got limited time here in the program, but it very often that when you've got this religious accommodation request and you're in an industry where you really can't afford to grant exemptions to your mandatory vaccination policy, maybe somebody's got a direct patient care facing role or something, a direct resident care facing role. And maybe you have reason to doubt the individual's sincerity of what they're saying. It's more of a political belief. Everybody knows who feels strongly on the anti-vaccine crowd. I mean, the response sounds something like this to me, is we appreciate all the information you've provided, regardless of whether you've articulated sincerely held religious belief. We cannot grant the accommodation you requested. After our dialogue, determined that it would be an undue hardship to provide that accommodation and a direct threat to the safety of yourself, our coworkers, our residents. However, what we're able to do in the alternative is to provide you a limited period of unpaid leave, maybe for the next 30 days. During that period, perhaps something will change. Perhaps there'll be new information about the vaccines. Perhaps the COVID variant will disappear, whatever. But that's the best we can do. And I think when that happens, if that's all, legitimate and needed based on the circumstances, you've covered your bets. You basically said, I don't know if that's a sincerely held religious belief or not. I'm not going to give that a green light. I'm just going to say, thank you very much. But even if it was, it's an undue hardship. The accommodation you're requesting isn't reasonable, where there is this direct threat to safety. And we have offered an alternative accommodation. That's a lot of embedded defenses built in. And of course, as I see the chat flying around here, the paper trail is very important on all this stuff. So we've got a limited period of time. We got to move on, but that's my quick takeaway on religious exemptions. Next slide quickly. This one is actually about a case in Massachusetts, illustrates the point. If you read the Supreme Judicial Court decision from 2008 in this case, the court is basically saying, look, if you know the answer is no, you don't have to engage in an interactive dialogue every time, but how do you know the answer is going to be no unless you engage in the interactive dialogue? So to me, that was a reminder of do the interactive dialogue, even if you're pretty sure that there's not going to be a way to do an exemption for this particular employee. You don't have to create false expectations, but do the interactive dialogue, make it particularized, understand what's going on, get the follow-up question, even if you're pretty sure you know where it's headed. And I think that the case law kind of backs that up. That's what that slide was about. Next slide. So what paperwork should we use to document exemption requests and exceptions? Next slide. There are forms. I mean, we've developed ones as starting points, and we've tailored them for clients. And the one I think that we use a lot and I like is it kind of puts them all together. It's a little bit of a check the box and fill in, a long narrative blank, but what's the basis for your request? Is it religious? Is it medical? Maybe pregnancy is included on the list separately, or maybe that's rolled into medical. So you're making the employee state the basis, and you're making them do it in a narrative fashion. When it's a medical request, there's going to be follow-up information from the healthcare provider, just like we would with any normal ADA accommodation request. And on religion, like I said, you kind of got some leeway as to how far you want to push the sincerely held religious beliefs. It may be that you don't want to push it that far, frankly, but it's, as I say, to some extent, a matter of personal preference. Another thing I add to these policies and exemption requests, even when it's approved, I started getting the habit of doing this for flu vaccinations, and every year was a little different. The flu some years was kind of bad and some years was really bad, and the thinking changed on how willing we were going to be to allow a flu exemption based on religion. So is COVID an annual seasonal thing? Not necessarily, but things change pretty quickly. And what may be able to be accommodated today may not be a month from now, 2 months from now, 3 months from now. So I find a way to embed that into our communications to employees and into our forms that, hey, this request is approved if it's approved, or for a moment in time, and things are subject to change, as we all know in the COVID climate we live in. Next bullet. Next slide, rather. Sorry. I mean, I'm almost content to have the information you request be this simple. You can ask for more. Like I said, there are follow-up questions. There's ways to do things in a tactful, appropriate way, but this is the heart of it. Hey, please explain, check the boxes, my religious grounds for my religious exemption. Please explain how vaccination would conflict with your sincerely held religious practice or beliefs. Boom, be specific, tell us. And that, to me, that's usually enough. You kind of know from that whether somebody's either serious or done their homework to at least appear serious. And that may be as far as you go on that. But so like I said, lots to talk about. The takeaway for me is, again, I'll reiterate it since I think this is the main takeaway, is I don't want to say it as hedge your bets, but I guess I say it as don't put all the eggs in the basket of being skeptical of someone's sincerely held religious beliefs. That is the lowest bar for an employee, a plaintiff, to clear, because we're not supposed to put too much scrutiny on that. Yes, if there's objective evidence, you can probe a little further, but I don't put all the eggs in that basket. If we're really in an industry where we have a mandatory vaccination policy, I may hedge my bets. I may not concede that they've got a sincerely held religious belief. I might save that one for another day. But the point is that after a dialogue, after a fulsome dialogue, after a back and forth, we determined that the accommodation you're asking for is not reasonable. It's an undue hardship. It could pose a direct threat to safety, and that maybe there's an alternative accommodation we've offered to provide. That is really as good a setup from my perspective, it's the pure defense counseling perspective, as you're going to get when the answer is no on some of these religious accommodation requests. So with that, I think we have a quick hypo slide on a slightly different topic next, but then we'll move on quickly. So this hypothetical was an employee requests an accommodation. It's granted. What information can be disclosed to others? Well, I mean, it kind of depends. There's a lot of unspoken going on there, but generally speaking, vaccination status is supposed to be confidential. I think the EEOC says it's medical information. And so I think we all know this. We wouldn't go around telling other employees, yeah, so-and-so's got an accommodation. So-and-so's got a religious exemption. So-and-so's got a medical exemption. We wouldn't do that. But how comfortable are we that other employees will be able to put 2 and 2 together? If somebody's got a different schedule, suddenly it's required to be social distance in some way, has a mask requirement that kind of highlights the fact that they've been given an accommodation. Is that okay? Is that somehow outing somebody inappropriately? I don't think so. I think it's part and parcel of the issue that we're dealing with accommodation requests. But so I guess the long and the short of that, from this answer from my perspective, is no, we're not affirmatively disclosing medical information or status or religious information about an individual. But if that can be discerned from an accommodation, so be it. I don't know if there's anything more to say on that. I'll stop talking. I'll turn it over to my colleagues to take the ball from here and to weigh in on anything else on this topic.
Just real quick on that last topic, Pete, if there is an accommodation for an employee that maybe impacts their schedule or their ability to do certain work or attend certain events, be able to, you can tell their manager or their supervisor, people who are on a need to know basis, in order to effectuate that reasonable accommodation. So that's a question that's come up a few times. You may not be, disclosing their vaccination status just as much as this is the, we're granting this person an accommodation, this is the accommodation, just so you're aware, because you manager are going to be responsible for some of that implementation. All right, so just moving on to the next, leaves for COVID related matters, and recognizing that we're light on time here. We do have a hypo on the next one, so let's just pull up the hypo and then I'm going to run through the answers relatively quickly, but everything's going to be up there on the slides. So an employee has tested positive for COVID-19 and must remain out of the workplace. The employee has asked about their options to continue being paid while out of the workplace, and has also asked about when they may return to work. So the employee is going to be out. They want to be paid while they're out, or see what they can do to be paid while they're out, and they want to know when they can come back. So let's go to the next slide. Like I said, I'm going to run through these quickly because, it's kind of laid out there, right? So what I have up here listed in the bullet points is the paid options, the potentially paid options, right? So we have the mass COVID-19 temporary paid sick leave law and the Families First Coronavirus Response Act. Those both expire at the end of this month. The FFCRA is already optional. So, many employers aren't really using that. The mass COVID temporary sick leave is mandatory for Massachusetts employers. And under that law, employees are entitled to up to 40 hours of protected leave for COVID related reasons, such as testing positive for COVID and, the time to be out of work for that, and up to compensation up to $850 while out on leave. And the employer can seek reimbursement from the state for up to $850. Again, both of those laws are expiring at the end of this month. And from what my understanding is, we haven't heard much talk about those laws being extended post 9/30/2021. But if anybody hears anything different, be sure to let us know. And we'll keep an ear to the ground on that as well. Also, they may be able to utilize their PTO or Massachusetts earned sick time benefit. They may apply for the Massachusetts paid family leave law. And remember, that's something that they apply through the state for, and the state determines whether or not they're going to be approved. And then finally, there may be an opportunity if the employee tests positive, isn't experiencing symptoms, and they do want to continue working, continue being paid. If remote work is an option, you can present that as an option for the employee while they're out on leave, so they can continue working, being paid while they're out on leave. Again, these are options. These are things to present to the employee. If they do have this type of question about what they can do to remain on, receiving pay while they're out on leave. Also consider for the unpaid options. If you are an FMLA covered employee, this may be a serious health condition covered under the FMLA, and you want to go through that regular process. And then also there may be an ADA reasonable accommodation for, an unpaid leave of absence. And then, when the return to work question, right here, we have bulleted out what the CDC guidance is concerning isolation after a positive test for COVID-19. So you'll see, if symptomatic, there are these 3 bullets. They have to before returning to work or ending isolation, it must be 10 days since symptoms first appeared and 24 hours with no fever, without fever reducing medications, and other COVID symptoms are improving, with the caveat that loss of taste and smell may persist for weeks or months and need not delay the end of isolation. If the employee is asymptomatic and they continue to have no symptoms, they may end isolation 10 days after a positive test. And I'll also note, I think Kathleen may have mentioned this before, but let me just mention it here because it seems to fit, is that the CDC has issued guidance concerning fully vaccinated people who have come into close contact with someone with COVID-19 but are not experiencing symptoms. And for those people, the CDC advises that the fully vaccinated person be tested 3 to 5 days following the date of exposure, and also wear a mask in public indoor settings for 14 days or until they receive a negative test. So that, again, that latter part is for fully vaccinated individuals who come into close contact with a COVID exposure. And with that, I want to thank everyone for attending and open it up for questions in this last 5 or so minutes that we have.
Mark, I want to comment one thing that I
Please.
correct something I said earlier when I said during my session about testing. The one black letter rule we have is that antibody tests are prohibited. Antigen tests are okay. And I think I had that reversed. So I wanted to make that clear. And also piggybacking off of what you're talking about, Mark, with the paid leave, I just want to point out that at some point this summer, the DOJ and Department of Health and Human Services issued an opinion letter or guidance about long COVID potentially being a disability. So I just want to put that on your radar as something that you might be seeing if you haven't seen it already with employees requesting leave, or they might be able to get that leave. That's again up to the Department of Family Medical Leave in Massachusetts, but that might be a reason for, that might be deemed a serious health condition. So we might be seeing more of that as we go on.
Thanks, Kathleen. And then, yeah, I mean, if they're, put it to Kathy, if there's any outstanding questions that may have popped up that, you know, we see out in the chat of. Maybe.
I see a chat on what are the guidelines when an employee is pregnant and is pushing back on getting vaccinated. Does anybody want to handle that one?
Yeah, and again, it's, you know, this is one of those areas, you got 2 lawyers, 3 opinions. We got 3 lawyers. I don't know how many opinions are, but I mean, this one hasn't come up for me that much. I almost feel like because employers, I don't want to say have a higher tolerance, but it's time limited in some way. I mean, my view is that in Massachusetts, you have to engage in the same, or you should engage in the same interactive dialogue with the pregnant employee who's requesting an accommodation from your policy, just as you would with a disability or a religious request. I've always assumed, and I'm not getting many pregnancy related questions, either because employers don't doubt the sincerity of it. I mean, it's kind of very apparent and visible, and they just know it's time limited. And so it's easier to sort of approve that request, and maybe harder to say it's a undue hardship. It doesn't mean you have to allow somebody in the workplace and create an unsafe environment for everybody. But, you know, again, I guess the real interesting question with the pregnant employees is this: there's a weird aspect of the law in Massachusetts that says you can't force, as an accommodation, someone to take a leave of absence, a pregnant employee to take a leave of absence if there's another reasonable accommodation available. So, but for that in the law, it'd be very simple to say, look, if a pregnant employee is saying, I don't want to get vaccinated while I'm pregnant, you know, my due date is X months away. I'd say, okay, well, tell you what, well, we can accommodate that. You can be on a leave of absence, so you can do something like that for a couple of months. That's an alternative accommodation than allowing you in the workplace unvaccinated. There is that wrinkle in the law that says you're not supposed to be forcing leaves of absence on a pregnant employee as an accommodation when another reasonable accommodation is available. So I guess you'd have to go through the whole analysis, and before you got to that end game, you'd have to be confident there was no other reasonable accommodation available. But that always seems to me like the worst possible end game. And the worst case scenario is somebody's on a leave of absence. The stakes just are lower with the pregnant employee. That's been my experience, but perhaps there's a fact pattern in the chat that this person's considering that makes it a little more complicated, but it just hasn't come up that much for me for those reasons. It's time limited. It's easier to accommodate. There's less resistance to the sincerity of it, et cetera, et cetera.
Yeah, I think you should consider, I'd say, the work environment too. I mean, you know, when we're talking about also undue hardships in that aspect, if you have been open and it's been a place where people are have been masked up, and you've been open since before the vaccine mandate and just requiring people to wear masks, it may be hard to push back and say, you know, that especially in that circumstance, that the mask isn't, you know, a reasonable accommodation that would allow the person to continue working, or that it would cause, you know, an undue hardship to continue to allow the pregnant person working. That's just one other point.
That's a great note to end on, right? So to the extent that exemption requests are such a big issue and thing for HR to be thinking about, the answer is always, it depends, right? We learned that and went to 3 years of law school to learn the answer is always, it depends. Well, it definitely depends. It depends on the facts when you're talking about accommodation requests. And it's all about doing the interactive dialogue. And it's all about back and forth and the sharing of information and what your industry is and what the person's position is and the length of the accommodation request and the cost involved and what other employees are doing. So you have to go through that analysis on a very individualized basis, really every time, in my view, with an employee requesting an exemption request. So if it sounds frustrating, when the lawyers say it depends, in this case, the law is set up to mean it depends. Do that interactive dialogue, do the individualized assessment. Everything matters: industry, position, person, condition, verification. It's all part of the mix. And obviously we're happy to help with that analysis in any given case. And with that, we're probably out of time for sure. Thank you everybody for your attendance and interest.
Thanks, everyone.
Thank you all very much.